Well, hello everyone, and welcome back to Uncivil Law, where as always, we learn through the misfortunes of others. For today's story, we have the latest letter from Sarah Boone. You'll remember Sarah Boone. She's accused of murdering her boyfriend as they played a game of hide and seek, and he hid himself in a suitcase in which he suffocated to death. And then she videotaped the whole thing, which is pretty good evidence of her involvement in the thing, as he begged for his life. And she's like, "No, not so much," and then let him suffocate to death. It's pretty horrific. It's on tape. Well, Sarah Boone, as I'm sure you will recall, has been told by the judge she has to represent herself because she has scared away her 8 attorneys. She had 8 attorneys, and she managed to scare them all away. And so she has been forced to represent herself, and she has written another letter to the judge, as she does from time to time, including when she was represented, because she's just that special. So we're going to read this latest letter and remark on it because Sarah Boone is just the gift that keeps on giving. So let's go ahead and get started with this. We note right away that it is dated July the 8th of 2024 in this sort of curly, cutesy font with hollowed out letters. And I'm not sure what's going on there. To the quote unquote honorable Judge Michael Koenig. Rule number 1, don't irritate the judge. Although I think it's too late. Regarding Sarah Boone, case 1 on many websites, 2020 CF 002603AO. Okay. Judge Kranick, where's my discovery? I'm still waiting for you to provide me with the contents of what my former attorney, Cashman, supplied to you. And the court, at the surprise, exclamation mark, status hearing held in secret. Well, no, you were there. It wasn't secret. You were there. And also it was televised. So no, not so much. On 6/28/24 at 1:30 p.m. Your designated clock of unfair judgment ticks empty and increasingly while waiting for you to deliver. As usual, it's in your favor. In your nonchalant, relaxed, unconcerned attitude of me to receive, you are robbing me of precious, life-saving time to fully and properly defend myself on top of my already and still being violated constitutional right and being forced to represent myself based on false information. Well, I don't know about the false information part because your own attorney said you were unworkable and they couldn't deal with you. And so, no, not so much with the unworkable. So no, not really, no. But thanks anyway. Yeah. I don't even know what is contained in said discovery after being withheld from seeing all to date. Let me read just the margins because apparently it's not properly on screen. Give me 1 second. No problem. There we go. Don't want you to miss any of her beautiful, beautiful verbiage. Her response to me, what I would have asked to review was, your first attorney said he reviewed with you. That was over 4 years ago. You're my attorney now. Who, the judge? No. And no, I didn't. That's what I have to deal with. I have not read it in its entirety and completely to date. Well, that's kind of on you. Please also know that I'm in an open bay dorm living with 63 other inmates. I need to figure out how to view anything securely in order to avoid further exploitation and mean ignorance. There is no privacy or individual access in the jail. Cashman, I'm glad I could help you shine in the courtroom in front of everyone by your professionally and finally bringing everything I've been asking for since day one. And after I included you on my letter to the judge ensuring return, unlike you who did not include me on your motion withdrawal. Surprise. And I had to find out from someone else, an officer, 3 days before the surprise motion hearing, so you would even know what to bring. Why didn't you bring to any of your 20 hours of meeting with me? As always, it's in everyone else's favor but mine. She's got a definite victim complex. That's much. That's fun. How much real time will I have to prepare and properly? You've got about 3 months, 2.5. Especially the fact that you've been doing everything while incarcerated. What happens when more time must be utilized to discover where my lost discovery is I've been asking for repeatedly? Not so much. For depositions to locate my witnesses. Contact anyone via phone calls. That's a real hurdle. Wait to receive transcripts, any records, everything I need to finally build my defense. Or is your plan, Your Honor, to just leave me out to dry and in a hurricane? I'd like to take note that those are kind of mutually exclusive concepts. Hurricanes normally involve water. Having recently gone through a hurricane, yeah. Your time constraints are extreme and unreasonable. Your decision to claim you have considered from your order is illogical, unfair, specifically that has been malformed by your ignorance, inexperience of my case. Misinterpretations, straight lies from the attorneys appointed. They are brazen to stand at your pulpit in your courtroom and commit perjury to your face in the world. All 8 of them? All 8 of them? Really? Okay. But yes, it's me. Hey, finally got a conclusion there. It is my belief, and from your order, that actions speak louder than words. The court is sabotaging me. No, that'd be mostly you. Forcing me, pressuring me, setting me up for failure. Again, that's kind of mostly you. If any of the prior attorneys would have corroborated during their time of representation, well, your last attorney made a point of saying she tried, and you walked out on her repeatedly, which didn't help. You're not being brainwashed, impartial, from believing everyone over me, and implementing your intricately misconstrued, unfair order formulated from, I would not be willing yet another letter, would I? In the meantime, ... while your clock ticks ceaselessly, and loud as I wait for you to deliver anything, even more fingers are noticed, that they really do point back. I mean, I appreciate the visual imagery. And I'm defending myself against your inaccurate libelous. I can write letters too, please. You know, not for nothing, but I'm not even sure that it's technically possible for the judge to libel you. I mean, it is in writing. But first of all, it's within their official judicial capacity, so they have immunity, absolute immunity at that. And second of all, even if it wasn't, it's within the context of litigation, which would lead to litigation immunity. So yeah, I don't think the judge can defame you. No, I don't think that's not the right theory. The judge could have prejudice against you, which could be reflected by the writings, which could be dealt with by a court. But strictly speaking, they can't defame you. That's not possible. But I appreciate your attempt. Moving on. How about the copy machine where your JAs should have made me the news crews, court TV, professional YouTubers, holla, and photographers, the world, a copy of the notice hearing where all aforementioned improprieties occurred, and then some, including drop-off of my case materials, said order being ordered, and me being pulled by my uniform to exit your courtroom while still trying to speak and defend myself against all the mayhem and chaos, especially the surprise, ! Of being there unprepared and without notice. Yeah. Tell it to the Court of Appeals. I'm sure they'll love to hear all about it. Good luck. I shall return. Of that much we are both confident. Nothing is impossible, believe. Hopefully, gratefully waiting. Thank you for posting. He doesn't really have a choice. He's putting it in the case file because, you know, he has to. Sarah Boone, number 20005623/FTC-B4. Remember, please judge Karnick fair, neutral, impartial. You must be always. Heart, I can do all things through Christ who strengthens me. Philippians 4:13. Well, that is in fact what Philippians 4:13 says. And then, of course, her ad. She wrote an ad, and this is my favorite. This is the best part. This is just the best. She wrote an ad. Inmate seeks attorney. Looking for a preposterous challenge? Well, that about sums it up, yes. Ready for your close-up on national television? Are you zealous with a side of keen? Show the world who you are. Original creativity, extraordinary expertise, confident ingenuity. Qualifications must include being trustworthy, honest, passion-driven, open-minded, exceptional problem-solving skills. You'll definitely need those for this case. Client inclusion at all times, team-oriented collaboration. I take notice at this point that, strictly speaking, if I were her attorney, and I'm half tempted to do this, I really, really am. There's a part of me, I don't know that I could get approved, to be honest, because I have no criminal experience. And my work was transactional. I really don't have court experience. So, asking a judge of a foreign jurisdiction to give me pro hoc on this case, I don't know, man. I don't know. First of all, I need a Florida lawyer to vouch for me. So I'm not sure about that one. Second of all, I don't know the judge would go for it. But, I am tempted. I am tempted because it would be interesting. And strictly ethically, as the judge himself has noted, I can kind of ignore my client. I don't necessarily have to make that particularly clear to the client, but I can, because we've talked about this delineation before. As long as we're going to try and learn something of value legally, which is probably a mistake, but let's try. Okay, the client gets to set the goal, the lawyer gets to set the means to the goal. So the client gets to say broadly, here is what I want to have happen. And everything else is left for the lawyer. This is true broadly of every legal field. So the client gets to say what they want to have happen. The lawyer says how, right? So that's the delineation. So in this context, the client says, hey, I'd really like to plead not guilty. It's like, okay, so that's your decision, right? I'd really like to plead not guilty and preferably be acquitted very much. Thank you. Don't you mind? Like, great. Thank you. That's fantastic. Now it would be up to me, the lawyer, to accomplish those objectives. And everything else is for me. Now, in the criminal context, there are a couple other things that are for the client, in specifically. So that's the broad principle. In the criminal context specifically, because of constitutional principles, there are a couple other things that are for the client. So the decision whether to plead guilty or not, the decision whether to waive a jury trial, assuming it's waivable, because in many states, the state has to agree. But, if they want to waive it, that's for them. The decision whether to appeal or not, the decision whether to take the stand in their own defense or not, right? So these are decisions for the client. But the lawyer gets everything else, including, for example, what other witnesses to call, what questions to ask them, what line of defense to pursue, and what lines of defense not to pursue. So I'm half tempted to do it because I can just be like, I'm ignoring you. And it is not malpractice, and it's not an ineffective assistance of counsel. As long as I can justify any of those choices, being like, this seemed like the most operatively valid choice, it is a legally correct choice. So it's like, yes, I can ignore my client. So I'm half tempted to do it, but there's that. Yeah. Yeah, Steve Gosney works for the prosecutor's office now. I'm not sure whether or not Steve Gosney can sponsor me, or whether or not that would be a conflict of interest for him now. Because I think Steve Gosney changed jobs recently, and now he works for the state. Now he's a prosecutor. I'm not sure whether or not he can sponsor me anymore, or whether that would be some kind of conflict of interest. I mean, strictly speaking, it shouldn't be, but there's probably something in there that makes it look weird. But whatever. But we could look into it. Anyways, the more practical problem is I have 2.5 months to prepare for a murder trial, because the judge has already said that they're not going to move the date. And even if I devote my every waking minute to it, that's a lot. And I'm not even sure it's hypothetically possible within the time frame, to be quite honest. So yeah, that would be the bigger issue. But so I might fail on this issue. I will include you at all times. Maybe less with the collaboration, although I don't necessarily have to make that particularly clear. Extreme efficiency in listening, communicating, and understanding. Sure. Dedication to success. See, that is the operative goal. As the lawyer, my goal is to zealously represent my client, potentially in spite of themselves. So yeah, possessing a winning mindset, capable of excellent in representation, committed, maintaining faith in the client, that again is going to be difficult, and the case with the ability to think different outcomes of all circumstances. Epic opportunity awaits. Sarah Boone, number 2005623, Orange County Corrections Department. Invest in the oppressed. Believe. I have to say, this is by far and away the best ad I've ever seen in my life for an attorney. This is the greatest thing I've ever seen in my life, and I want a piece of this. And then she has, she wrote legal mail on it to the judge with the postmark and all the rest of it. So yeah, good times. So I'm half tempted to do it because, well, yeah, although you have a pretty reasonable, and again, like the ineffective assistance of counsel is a really hard argument to win, particularly under these constraints. So, I could probably do it and probably survive ineffective assistance of counsel on appeal because it's a pretty low bar. It's a pretty low bar to be. So, yeah, the fact that I have no trial experience, this doesn't necessarily preclude me from taking this case. Yeah, so it could be fun. She is impossible. Yeah. So all the rest of that stuff. And, we never read the other Sarah Boone letter before, and I feel like we should. So let's go do that. I need to find a copy of it real fast. So give me a moment while I pull up the 53-page letter, and we'll read her prior missive, which was also exciting and fun. Mindset. Oh, that's true. Mindset technically is a Florida lawyer. I don't know whether or not he could do it either because he's not there to supervise me. So I'm not sure whether or not he could ethically do it. Tragos, I don't think would do it. Tragos doesn't know me. I mean, we don't really know each other, so I'm not sure Tragos would do it either. But yeah, technically Mindset is technically a Florida lawyer. So can he sponsor me and supervise me from Korea? Is that an option? I don't know, man. I don't know, but it's a thought. It's a thought. It would be something, that's for sure. And then she's absolutely going to take the stand. She is, right? She's going to take the stand. So I'm going to have to work on my direct for Sarah Boone. Wow, that's going to be amazing. I mean, I'm going to tell her not to. Of course, I'm going to tell her not to. But we all know she's going to, right? We all know she's going to, right? So, yeah. I can't make her. Sadly. You can't wait for that cross? Yeah. Just be like, well, what am I going to do here? Roll that beautiful bean footage, baby. The videotape is going to, yeah. We're going to spend some quality time with the videotape, I imagine, on cross. I'm going to have to bring it out on direct. I'm going to have to direct her about the tape. I'm going to have to try to draw the sting. So draw the sting is this idea where you want to mention the bad piece of evidence first, which you always do because you have control over it, right? So if you have a piece of bad evidence, you want to get out in front of it. So if she's going to testify, which she absolutely is, she's going to be crossed on the tape. Of course she is. So that means I have to direct her on the tape, which means I have to figure out fun and exciting ways of presenting the tape and making it not look like a horror show. Exciting. I can do it. I believe in myself. I am all powerful. Doesn't she maintain she doesn't remember making the tape? Well, if that's what she says, then I guess I'll go from there. Yeah. Now we're okay. Here's the previous 58 pages of glory. Oh, there was another one. Oh, there was another one recently. Okay, so before the 58 pages of glory. Yeah. She was drunk as a skunk? Well, depending on the finer points of Florida specific law, that might be a defense to some version of murder. So that again is a thing that can differ from state to state, by the way. I'd have to go double check, but was it Minnesota or something that made that point of difference where it's like you actually, so yeah, whether or not you can use the intoxication as a defense, typically the answer is no, you can't, but some states you can. But, we could check out the finer points of Florida law. So we could try to use the intoxication as a defense. It's like, okay, that'd be good. All right, so we have this one from a couple days ago, June 25th. She's a loon, run. Yeah. June 25th, Your Honor. It was made known to me by an officer here at Orange County Corrections Department that my attorney, Patricia Cashman, has submitted her motion of withdrawal on 6/11/24, which now explains why she's not contacted me nor answered my calls. Why hasn't anyone sent me a copy so I know? That's actually a reasonable question if no one did. I have to, hold on. Let me just see if this is urgent. Hey, Nate, I'm streaming. Can I call you back? All right, cool, man. I'll talk to you a little later. Thanks. All right. Let's see. Why hasn't anyone sent me a copy so I know? Yeah, that's a good question, assuming she wasn't sent a copy, but I don't know about that. To confirm my exclusion in my case, especially by Attorney Cashman, and stated in all my letters previously written, I was not included and am finding out weeks later. Judge Kranick, I am trying to receive, please, a copy of her withdrawal to better understand her reasons for the undisclosed departure from my case. Number. Attempt was made on her part to solve or remedy in some type of discussion professionally beforehand. Therefore, I'm having to include you for this request as I did with my most recent letter. Please understand, I'm trying to understand. With her attempted withdrawal, my very legitimate concern now is not having all my case contents returned to me, as with most of the prior attorneys. To date, many of my evidentiary case items cannot be located after numerous requests to the attorney of my care at that time and to the attorney Cashman. No one knows where my case items are, who has what, or cares to research and return now that I'm no longer under their representation. Shrugs, shoulders, avoidance, and lies of where anything may have been is all I've received when requesting the former unwilling, disingenuous attorneys. These are my case documents. Attorney Cashman stated to me more than once from me asking repeatedly about that she had reviewed all my discovery, which I was withheld reviewing also, which sometimes is possible. Sometimes the things are attorney's eyes only. So that's possible, although that's rare. And so I don't even know how she had specifically and completely and was available to me. Your Honor, how can I ensure, please, the return of all my case contents from Attorney Cashman? When may I finally review my discovery and the contents she has of my case so I know what is still missing or lost? Pardon me for having to utilize your invaluable time to have to receive my invaluable case items. Please understand, I'm trying to understand how and when I can fully, rightfully defend myself. Due process is due, overdue. Neat. She received them the day after this letter when they were delivered to her. I believe it. I thank you in advance for my inclusion to also receive a copy of the attorney's withdrawal notice and for helping in the ensurety of all my case contents to return successfully for my historical review from Cashman. All other former attorneys, please, if possible. Judge Kranick, you will never understand my gratitude for listening to me, giving me the opportunity to finally be heard, and for your apparent caring judicial manner. Thank you immeasurably. I await the next appropriate step in moving forward, however, and with whomever. Sincerely, Sarah Boone. For inclusion futuristically, and to ensure receipt of all my correspondence to me. In my case, my address is as follows. I'm also including the attorney with a copy of my letter, mailing it to Concord Street. Neat. All right. And then we have her 53-page letter. 53 pages of just glory. 58 pages of glory. This is my client, baby. This is my client. Yeah, I can make this work. On the plus side, representing her, expectations for me as an attorney are so low that, it can't possibly go that bad for me. I mean, how badly can I possibly fuck it up given that this is my client, right? I mean, the bar for success is so low that even on civil law with no criminal history experience should be able to pull it off. Good times. All right, hand delivered June the 7th, 2024. This is when she was still represented by an attorney. Honorable Judge Kranick, ongoing 5 years. Yeah, I think that's part of what the judge is irritated about. Why can't I use my constitutional rights? Am I the only one who cares about ongoing violations of? Have bond. Well, the murder charge would be the principal reason. Have all my medical records. Have all my digital evidence and discovery. Because your lawyer has them. Have all my paperwork, notes, letters, pictures, everything of mine returned by my former attorneys. Well, no, it would go to the new attorney. That's how that would go, right? So if a new attorney takes over, they get the files from the previous attorney and we all move on with our lives. So if I became an attorney for her, I'd have to get it from the prior attorneys. Assuming they still have it at this point. Lord have mercy. Speak to my investigator. Again, that would not be typical. The investigator works for the attorney. Why would they speak to the client unless there was a reason to? Have complete download of my phone. Have any of my witness lists. Again, that's for the attorney. Give any insight, understanding, clarification, truths about my case, especially to my attorneys. If you didn't walk out on the meetings with them, that would probably help. Be listened to anyone, especially by my attorneys. Yeah. If you mean like agreed with, if you mean I get to command the attorneys, no, that's not how that works. No. It's like hiring a professional for any other job, really. Fundamentally, it's right. If you hire someone to do the job, you tell them to do the job. You don't then tell them how to do it, right? If you hire a plumber, right? It's like, okay, what is the goal? I want my sink unclogged. My toilet is overflowing. Please make it stop. My shower doesn't have any hot water. Can you help me get hot water, right? So you, the client, set the goal. You then don't go and tell them how to do their job. The plumber will hate you. They don't like micromanagers. Every professional will hate you. You don't tell the mechanic how to mechanic. You don't tell the plumber how to plumber. You don't tell the lawyer how to lawyer. It's like, you set the goal, I figure out how to get there. Leave me alone. So, be respected for who I am truly. I think we all do respect you for who you are truly. That might be part of the problem. Especially by my attorney, and not disrespected for the something malicious murder all the world has falsely, incorrectly created and believes me to be. Well, we do have the tape. Be treated fairly, lawfully, and protected by the justice system. Properly, rightfully, completely defend myself. Yeah. See all and know all the same world can and does, including my attorney, from all the phenomenal, non-permissive amount of my entire case being available online globally before my trial, which you yourself have contributed quite a lot to that, to be quite honest. And most importantly, before I've seen it myself. What doesn't anyone know already about my case? How about my side and everything? What exactly is your side, incidentally? Be correctly understood that I am not the problem. I don't know about that. For reasons I am on mal-appointed by court attorney. See my letter 721. Say what I want and should, but all the world can and say it wrong and warped. Why won't my attorney give me an honest answer? They probably are, you just don't like the answer. Show me everything she says she has and finish reviewing for my case, but withheld from me after getting repeatedly. Again, because that's not really, I only need you for certain things. I don't necessarily need to share with you everything, and I'll take care of it. That's my job. Give me an answer other than I'm putting this to rest. That isn't necessary. I'm not having this conversation. Again, the lawyer gets to make those calls, strategic and tactical calls. So it's like, I've made a decision. This is what we're doing. Choo-choo. Choo-choo. You know, it's like, well, you can fire me, but as long as I'm your lawyer, you know? Like the detectives in this case, stop putting words in my mouth. Your own words are more than effective enough. Tell me what's going on in this case. It's been well over 100 days. She's been my attorney. I still don't know. Ongoing 5 years. Answer any of my questions. It sounds like she tried. Ever ask me any questions? Maybe she doesn't have to. How can she supposedly know everything she needs to know from what she's been told, heard, read, seen? Discovery. Reassure she's on my side for me, not against. Why have I already been judged in the court of public opinion? How'd that happen? First Amendment. Glad I could clear that up. Why have I been sentenced by anticipation and condemned before my predicted trial? You haven't. Why does my attorney and all the world think my case is already over? Because we can't find any really viable lines of defense. Or at least that's the problem, right? It's like your attorney can only do so many things. And it's like, yeah, well, you know, I'm not a magician. I'm not a magician. So if it's all over by but the crying, I will tell you. You know, I can put the state to its burden, but if I think they're going to make it and I don't really have a counter, then, you know, we're kind of toast. So that would be why. All right, let's see. The race to the pulpit is unfair and important to me that you are aware and understand what transpires when the news cameras are off and we're all in between my status hearings. Two, as so many of the advantaged embezzlers, racketeers, mindless lemmings, and just altogether mean people can use their freedom of speech, not knowing me in any way other than what's being said about me by all the other mean people. The tape did help. And being said incredibly incorrectly, so can I. Well, we can defend it in court to the extent that we can. As compelling annoyed detectives in my case, Cosprell had falsely documented and Lowen were his gun for me to see. I am sure you're familiar with after watching all my plastered, highly misconstrued, over 30 million plus views just on one site interviews, and in which they both repeatedly attempt to feed me their incorrect, incomplete, hypothesized opinion by stating to me everyone has their limits at this seemingly endless point of perpetuality of nonsense and lawlessness still growing, and I very much want to advance to the next level after ongoing 5 years now. A genuine concerned limit has been reached. Well, the judge agrees with you on that one. Why am I still not being included in my case? How much more of my case and self is being added hourly, especially after this letter gets loose to the internet? Increase the mass infection and destruction of my hopes to have a fair trial, anything fair, my side foremost, and wondering now, like my attorney, drank the punch like everyone else. Yeah. All aforementioned reasons, and so many more for this letter, is being written up to hope to deter some of the unfairly one-sided finger-pointing of corruption and malpractice being directed at me only by those in the justice system who are trying to deflect the shame and shock from me furiously challenging the status quo, and it must be so because it's my face on the computer at the same time on my boob tube television, brainwashed, ignorant followers of disbelief, conformity, and greed, trying unsuccessfully to make my life by character assassination seem worse than theirs. One, it's impolite, and two, 3-point back at you. How many have tried to see? Put the stone down, as there will be no casting of anything today, except maybe for the role of my part for the all pre-conclusioned documentaries and crystal ball real-life stories of true crime incorrectly formulated from everyone supposedly knowing me and judging who they think I am, what really happened and is going to futuristically. Remember, 3-point back. Soothsaying is not a real job. Okay, to sum it up in the words my attorney after I told her to Google me, she stated, there's a lot. Yeah. To sum it up in the words of myself, the defendant, stated to my attorney after she stated that to me, when can I see? How much longer do I have to wait? Or how many attorneys must be withdrawn from me to be included in my case? You know, as your potential future attorney, including you in your case does not seem like the best strategic decision. I'm getting the sense of why I as your hypothetical attorney might not want to include you in things. Yeah. See all my aforementioned outgoing 5-year questions I'm still waiting on for answers. Also, is it ethical as her hypothetical attorney that I ask that she be bound and gagged in the courtroom? Is that ethical? Can I do that? Well, let's see. I am trying to forward my client's interests on the one hand, but on the other hand, it does literally put a muzzle on her in front of the jury, which isn't really a good look. So I'll have to debate the ethics on that one some more. Two retarded, vicious circles we enter every time we meet is a waste of time. And I'm saying that being in jail with my supposed endless amounts of how she treats me is extremely prejudicial, hostile, and unconcerned. She is very frustrating. To balk or defeat an endeavor, to induce feelings of insecurity, discouragement, or dissatisfaction, to bring to nothing. So much I've presented my solution in order to coexist with and work together in a hopeful, progressive, positive, appropriate manner. I added pretend judge to our interactions, so she should calm down and ease up on her condescension, offensive demeanor, and obvious prejudgment. So she, like everyone else, not to remember I'm innocent until adjudicated otherwise. Yeah, but we all see where this thing is going. She treats me as if she's not. She probably has a very realistic understanding of the evidence. And probably trying to tell you some hard truths. After my introduction and explanation for my pretend judge in the room or on the phone, I'm trying to help her understand how she's making herself extremely unwelcoming. Oh, Lord. My attorney, everyone should be fair, unbiased, trustworthy, honest, supportive, informative, protective, automatically and effortlessly. I should feel secure, highly confident, proud in her representing my life. I do not, and have said to her many times regarding her something mental disbelief in me and my case, which I believe contributes greatly to her inseminal attitude towards me. I'm hoping by this letter she will pick up the sword of injustice and fight alongside me, not against me, where so many unmotivated, underwhelmed, weak attorneys prior who bowed out ungracefully and crept away from the battlefield unsuccessfully. My case equals bizarre, equals unknown, equals different, equals ignorance, equals misunderstood, equals unfair. This does not mean my case can't equal success, and in more than one way. If I could succeed in getting a not guilty verdict out of this case, I'd be a fucking legend. Could you imagine? Could you imagine if I took this case and somehow got a not guilty verdict out of this jury with all this? Could you imagine? Holy shit. Holy shit. I am not a murderer. The justice system should equal fair, faith, true, respect, innocent until and adjudicated otherwise. 3-point back, Sarah Boone. Confused cat meme. Yes, thank you. Okay. Video visit, 12 minutes. In addition to my previous letter intended for hand delivery on 6/7/24 at my status hearing, today my attorney made a video visit to go over everything I've been asking her for and have also sent to her personally in 2 letters, all on public video visitation box, where on both sides of me, less than 5 inches away from my visit, other inmates were having their visits also. I have explained to my attorney numerous times previously in writing and verbally that despite the noise level, I do not feel in any way feel comfortable having in-depth private meetings regarding my entire criminal case on the visitation box, where there's no privacy whatsoever, and held in an open bay dorm with more than 62 other interested all-ear inmates. I mean, there's a point to be had there. I cannot fully participate, if at all, from the entire dorm, officer included, trying to participate also in my case. I mean, your attorney has to be way aware of this. And so, like, I wonder a little bit what's going on, because I'm guessing it maybe isn't what you're telling me it is. After repeating to her over and over and over, while she's still beginning to speak louder and over me, still to please schedule an in-person meeting where all can be discussed further, privately, with no success of being heard, I disconnected the video telephonically. She uncooperatively. She's impossible. See previous letter or ask her for a copy of the 2 I sent to her. I was trying to remedy or lessen before sending this to you, Your Honor, and not having to include. Now it's a race to the pulpit. My question, please. Who gets to ask like that and still be able to call themselves professional? The visitation box is primarily family and friends to connect. And if a must from an attorney, reminders, notices, quick questions, not high-level confidential communications. She, like other former attorneys who always blame their dysfunctions on me, said, "You don't like the answers I give you." What answers? See pages 1, 2, and 3. I am not the problem, except that I want to and should be treated fairly, with respect, acting more professional than the paid. I've been doing this for over 40 years professional. After so long, and all the experience, common courtesy, customer service, and listening skills should have been acquired. And attorneys, do you remember why you even wanted to be one? Remind yourself. No one listens. And if it works in everyone's favor but mine, that I'm a murderer stuck in jail, so they can pin on me they're uninterested, unmotivated, hopeless, they're going to leave me over her haughty attitude. I am not wrong for not thinking less of myself, because everyone else has and does, the present attorney foremost. We might be, I can sense some reasons the attorney might not necessarily think that you might necessarily be the most credible witness, for example. I'm getting some indications from that. The justice system expects me and other clients to accept in its subpar, nonchalant, hypocritical, next on the list attorneys they keep endlessly throwing darts for and malappointing, praying they don't withdraw. I have not fired any attorneys appointed me in my case, from me expecting their highest equal standards possible, for wanting the absolute best outcome in my preposterous, mismangled case. And representing myself is not an option. It seems like it is, as both judges have now threatened me with from being outspoken and intelligent in all my observations of the ongoing abuse I am and have experienced. I have no new experiences from it always being the same. Blame Boone. I refuse to be moved in waiting respect, no matter who everyone thinks I am. Clarity, inclusion, honesty, and professionalism. And another great reason not to have my case meetings on the public visitation box is my personal confidential inmate information, such as my visitation lists with names, etc., my interactions with inmates and officers, who I've eaten, when, and my personal jail calls also being thrown online. For what? To hate me more or try to get others because I don't eat breakfast or because I know some Latin? Oh dear. Have short hair, my penmanship is nice, or because I'm not getting fat and sleeping all day, but rather fully applying myself, fighting still, making everyone upset for not having to fabricate, restate, splice, edit. The world apparently knows all. What's next? How many times do I have to go to the bathroom, and what function I perform? Okay. No one knows anything, nor seems to want to be, from being comfortable in their corruption and striving to be on top with their ratings, web hits, and money. My case details, if anyone forgot, and if you think about it, all that keeps getting plastered and plagiarized, posted, and poked fun at about me is all in my favor, proving myself right about all the mindless lemmings, shut-ins, the justice system advantageously abusing and profiting from everything in my case before trial and before I've seen. Please be sure to reach my attachment for FRCP Rule 3.220E, restricting disclosure. Am I the only one who thinks of these things? When can I win? I'm not sure that day's ever going to come. And anything. It's coming. It's not. I'm not the problem. I think you might be. And if anyone were to slip on my side and have to experience, tolerate, deal with any of what I have and what I am, would bravely be doing the same. Don't knock it till you try it. 3-point back, race to the pulpit. Again, always, Sarah Boone. And then she cites some relevant rules of discovery. And I do have to agree, her penmanship is quite nice. So I will give her that. I mean, my penmanship sucks. It is horrible. My handwriting is trash. So, I mean, yeah. It's like a race between me and a doctor, man. My handwriting sucks. So I will give her this. Her handwriting is very, very nice. So she quotes some relevant rules. She just quotes the rules with no particular analysis, incidentally. And then what is she quoting now? She just says, quote, that the individual shall have full protection in person and property is a principle as old in common law, but has been found necessary from time to time to define anew and the exact nature excellence of such protection. Political, social, and economic changes entail the recognition of new heights, and common law, in its eternal youth, gnaws to meet the demands of society. There, in early times, the law gave remedy only for physical interference with life and property, for trespasses, vit arms. The right to life served only to protect the subject from battery in its various forms. Liberty meant freedom from restraint, and the right to property secured to the individual's lands and cattle. Later, there came a recognition of man's spiritual nature, of his feelings and his intellect. Gradually, she's quoting the Declaration of Independence. That's nice. Gradually, the scope of these legal rights broad end, and now rights come to life mean the right to enjoy life, the right to be left alone. The right to liberty secures the exercise of extensive privileges, and the term property has come to compromise that's Black Law, or the Bluviar's Law Dictionary. She's not even Black's Law, some other bullshit law dictionary. Then she cites the American Declaration of Independence, the Florida Constitution. She defines what a client is. She defines what attorney-client privilege is. She defines what zealous advocacy is. An attorney must represent each client to the fullest extent under the law and require representation to the attorney's fullest ability without violating the rules of professional responsibility. It requires not only presenting each argument required by a client to the very institution in which the client has business, but also framing each argument in the strongest terms of law that greatly benefit the client, while remaining faithfully to the law in itself. Yeah. Zealous advocacy is a requirement of the oaths required by an attorney, admitted to success of the adversary system of justice. Disruptive, disrespectful, degrading, or any disparaging rhetoric is never the inclusion of zealous advocacy. Citing some, again, bullshit law dictionary. And the use of such crosses the line from acceptable, forceful advocacy into the unethical conduct. Well, I appreciate the Bouvard Law Library on this issue, but whatever. Defining attorney misconduct, defining duress, defining the writ of habeas corpus, which she notes is called the Great Writ, defining informal consent. She was right the first time on informed. Legal ethics, equal protection of law, abuse of process, interrogation, custodial interrogation, excited utterance. Here is a map. What the hell is this map? Publicity, exploitation, and saturation. Okay. Apparently that's where she thinks her case is being covered and discussed. To date, each star is a state where I've received correspondence via mail or message regarding my case. Okay. Invasion of privacy, defame, invasion of privacy, false light, publicity, exploitation, and saturation. My personal individual criminal case is being advantageously exploited and abused from all my significant, life-saving, suppressible case details, evidence, proof being illegally obtained by coercion, trickery, which is legal, duress, not so legal, confusion, might be legal, and without my permission. In any form, written or verbal, to anyone, then broadcasted, distributed, hand-delivered to the entire planet, states, counties, continents, containing all my potential jurors, causing irreparable, erroneous falseness, greatly tainting my jury pool, altogether by forcefully attributing heavily influenced, incorrect, inappropriate motives, theories, and ideas. It's almost like the public trials occurring in the public in a public way. It's almost like the public trials occurring in a public way before the public. This obvious exploitation and invasion of my privacy is creating unnecessary, unlawful oppression, depleting all my entitled opportunities to be given fair, proper, successful conclusion of my case. Something prejudgment has already been made unfairly against me from the undeniable violations of my rights and due process of law. No. As a result of my entire case and personal life being publicly, globally, before my right to trial. Yeah, the First Amendment exists. Which lawfully, ethically should be without disadvantage and free from all particulars, deceitfulness, and dishonesty made from evident exploitation. Okay. And then she cites some dictionary definitions of various things. Procedural due process, substantive due process. She publicized to bring public attention, to advertise. So that's nice. More definitions. Excited utterance, which is an exception to Miranda, because it's spontaneous. So excited utterance is, well, an excited utterance, strictly speaking, is when someone says something, usually because of a sudden, unexpected situation that emerges, right? Oh my God, the car's going so fast, right? It's something said spontaneously without time to reflect due to an emergent situation. And it's also an exception to Miranda. Well, not really, because it doesn't result from questions, right? So if you chase down the suspect and they just start blabbing things, then, well, you didn't ask him a question. So Miranda doesn't apply. So, yeah. FOIA, and that's the end of the letter. She's a lot. She's just trying to educate the judge. I think the judge knows. I think the judge is well aware. So she's a treat. She's a treat. How's she competent? Competent is a low bar, my friend. Competent is a low bar. You know? Yeah. Your own personality defects don't qualify as incompetence. She's competent. She's clearly able to put together lucid thoughts in a coherent manner. She just is insufferable. Insufferability is not insanity. So, yeah, she's competent. You know, and is that she's a B to the EITCH on a lot of levels. Yeah, I'm not sure she could plead insanity. I'm not even sure it would be effective necessarily. You could try, but I'm not sure what evidence is available for insanity. If she has history of like mental health problems and institutionalization and such and so forth. Yeah. Green Eyes Other Girl says you're enjoying this on a road trip. I'm glad you are. Yeah, so I'm half tempted to represent her. I'm not sure the court would accept me, to be honest, and I wouldn't blame them because this is so outside my wheelhouse. This is so outside my wheelhouse. So they probably wouldn't accept me. But then again, the alternative is Sarah Boone pro se. So who can say? She has a history of heavy drinking. I suppose I could try to prove. Again, I need medical reports to prove it, but I could try to prove basically that she's had brain damage from heavy intoxication use, which would be like a physical issue. She's caused some sort of physical ailment to her brain. I could also try to prove like alcohol-induced psychosis, but that's really hard. Yeah. No publicity is bad publicity. Take the case. Yeah, the problem is getting up to speed fast enough. It's like even if I dedicate every waking hour from now to start a trial for this case, it's like first I'd have to get the discovery, which alone would probably take a couple days. And then like even if I devoted every waking hour to like going through this to get ready in 2 months for a murder trial, ugh, it doesn't sound fun. It doesn't sound fun at all. Yeah, MRI of her brain. Yeah. Take the case and get her to sign a waiver returning client privilege. I'm not sure I would advise her to do that. As her lawyer, I have to look out for her interests. And although her attorney client privilege is running pretty thin at this point because she keeps like saying everything to the clerk. So I'm not sure what's left of attorney client privilege at this point, to be honest. But for whatever value it has left, yeah. Yeah, the trial starts October. I think it's October 5th or something like that. Something like that. Yeah, it's coming up pretty fast. Yeah, the brain damage defense didn't work for Shabusiness. Exactly so. Yeah, it didn't work for Shabusiness either. Would the things on Civil Senate stream disqualify him? No. Absolutely not. No, wouldn't disqualify me. No. If I take the case, I'm moving in from one capacity to another. And everything I've ever said is evidence. So they can't like impeach my defense using things I've said on YouTube. That doesn't make sense, right? I'm not the client. So it's like they can't impeach me, right? So no, it's absolutely not a problem. Like the jury would never see it. The jury would never see anything I've ever said. Because it's not evidence. It's not evidence of anything. And it's not impeaching because I'm not on trial. So it would be completely irrelevant. So no, it wouldn't disqualify me. The relevant legal question is twofold. Um, well, I suppose really onefold. Really, it's like, can I give her zealous representation? Which is to say, can I give her? Can I advocate for her interest in whatever manner that would be as I see fit, based on the available information, and which would also, like, can I be competent while I'm doing it? So that would be the only, like, issue. But no, it wouldn't. No, I could take the case if there's nothing that would stop me. It might prevent her from hiring me, but she wouldn't know about it anyway, so what does it matter? Yeah. The real problem is getting up to speed fast enough. For a murder trial, I don't think it's possible. I don't think it's possible. You would never get through discovery. You couldn't do it. And then also, like, trying to figure out what witnesses I have for my side, which I don't even know what that would be. Especially at this point, I couldn't probably get an expert on. So probably not the best case for me. Probably not the best case for me to take on. I think I'll just sit this one out. Is it being streamed? Oh yeah. Yeah, it'll be streamed. It'll be streamed. I have 2 days to file all the pretrial motions. Ooh. Yeah. That's gonna be rough. It's gonna be rough. I might have to sit this one out, guys. But not dealing with her is an option. So, you know, I just have to forward her interests. I don't necessarily have to talk to the client. Um, so yeah. Yeah. 2 days. Yeah, I could. So I'd have to file on Monday. That'd be so. How am I supposed to get her to? How am I supposed to get hired by Monday? I'd have to call her in the jail like today, and I'd have to find someone who can sponsor me, and I'd have to file a motion for pro hoc vice plus all the other pretrial motions on Monday. Yeah, I don't think that's going to happen, man. Um, Especially since I don't have a discovery. I don't even know what to file motions for. I mean, I want to file motions in limine, but I can't file motions in limine because I don't know what I'm trying to limit. So yeah, that's not really going to happen. Yeah, yeah. It would be rough. You'd probably watch me get my ass kicked in court. You'd watch me absolutely get my ass handed to me. You know, yeah. Maybe the rest of LawTube and I can have, like, daily. We can have post trial calls. They can give me advice. That'd be funny. That'd be funny. I hop on the call at the end of each day into the LawTube stream and be like, "Okay, guys, you have any tips for me over here for tomorrow? Anyone have any thoughts?" Yeah. You think I could get a sponsorship for the trial? Get sponsored by Samsonite? That'd be good. This LawTube stream is brought to you by Samsonite, the best in luggage. Samsonite luggage will not break or bend or is ever reliable and secure. Lord. Did I see her flyer? I did. Her flyer is brilliant. Her flyer is wonderful. Her flyer is glorious. Yeah. I get my ass handed to me in court. I get my ass absolutely destroyed. I get completely destroyed. She's going down hard. Get sponsored by Attorney Tom. Yeah. That's me really be yelling into the phone about why you ever thought it was a good idea. That sounds about right. That sounds about right. All right. Gosney's Florida. Yeah. Who's Sarah Boone? Crazy woman. Yeah. If somehow I managed to win, or even got a mistrial, even if I could get a hung jury, I'd be famous. If I could get a hung jury out of this, I'd be like so happy. I don't really blame anyone who refused to sponsor me. To be honest, I wouldn't blame them for refusing to sponsor me because, you know, it's a lot. It's a lot. It's, you know, I don't have the expertise, and this is such a condensed time frame. It's like there's no way. You know, it's not just a matter of raw intelligence. It's a matter of time, and it's a matter of being able to get through the material, and it's a matter of I could probably understand the state's case within the time frame. But I doubt, so I probably could understand the state's case, but I would not have any time to put on my own case. So my only witness might be Sarah Boone herself, which at that point I can just throw in the towel. Although Sarah Boone getting on the stand and testifying and showing her mental qualities might allow me to make a backdoor insanity argument. I can make a backdoor insanity argument because I might not be able to plead insanity, but I can always argue insanity because I'd just be attacking mental state. I'm attacking mens rea, right? So if she gets on the stand and absolutely like craters herself, which sounds pretty likely, I can always go for a Hail Mary in close and attack mental state and be like, well, you heard her on the stand. She's insane balls, and obviously couldn't form the requisite intent. So therefore you must acquit. So I could do a backdoor insanity argument. So that might work. Yeah. Is insane balls the correct legal argument? The correct legal argument is whatever will persuade the jury. You know, Florida is well known for its Florida men. Those delightful characters who entice us and enthrall us with their hijinks and questionable decision makings. But my client, Sarah Boone, is obviously of a character so far gone that even Florida man is like, damn jury, she be crazy. Ladies and gentlemen of the jury. I mean, you know, it would be different. It would be different. It would be different. It would not be your typical closing, that's for sure. Lord. Yeah. I can't really use profanity, but just about anything else I can get away with, you know? So, yeah, I mean, it would be an unconventional argument. Some of my fellow brethren lawyers might argue it would be an unprofessional argument for me to approach it that way, which would be perhaps viewed by many as unduly casual and not representing the profession. But hey, if it works, I'll be seen as a brilliant genius. So okay, you know, yeah. I don't think a high-minded rhetorical approach would be the way to go here. I'm thinking. I'm thinking low comedy would be a more appropriate approach here. Uh, so yeah. Also, I need to file a motion so I can wear my hat. So I don't know if that qualifies as a pre-trial motion or not, but I'm filing a motion so I can wear my hat. Motion so I can wear my cowboy hat because it's part of my shtick. Yeah. Didn't stop profanity in the trial. Well, there the profanity was coming from the testimony. It wasn't profanity for the sake of profanity, so that's different, right? So in that situation, the profanity was being used because it was what was being said. It was evidence, right? So the profanity was the evidence, as opposed to just profanity for the sake of profanity. So there's the difference there, because that's just what the witness said, right? And if I decide to quote the witness as part of my argument, I'm not using it's a use mention distinction if you want to be really hyper technical about it. It's like I'm not using it, I'm mentioning it. It's like I'm not using the word, I'm mentioning the word. So yeah, that's the difference. I can fix her. I know. I can fix her. I believe in myself. I can fix her. Not only will I get her acquitted, but I'll get her to see Jesus. And then I'm gonna have her, and then I'm gonna have Trump nominate her for something. I'm not sure what yet, but I'm sure she'll do great. Don't let her know I'm unmarried. I don't think she's the woman for me, guys. Department of Education. Yeah. Yeah. I'd probably, if I really put my thinking hat on, if I really put my thinking hat on and got like all the discovery tomorrow, and I have 2 months basically, and I could spend every waking minute on it because I don't have a full time job, so I could spend 2 months straight just staring at the files. I might be able to successfully understand the case, and I might even be able to think of some potential cross examination questions. I seriously doubt I would be able to put together any theory of the defense case, even if one had already been created by other lawyers I could piggyback from. I wouldn't be able to get the pieces assembled in time. Not for at least the reasons that I'd have to send out subpoenas, and I'm not even sure that I could do that at this point. So yeah. Kurt's legal case choices should be based on hot scale mugshots. Fair. But the state would crush me. The state would absolutely crush me because they have all the time and all the experience. They have all the experience from all the trials, and they know the case cold. I'd be flailing around. They'd crush me, and I'd probably get embarrassed on more than one occasion by dropping something or forgetting something or making myself look like an ass just because I was trying to get up to speed so fast. Although, I could try the whole I'm just a simple country lawyer thing. No, I'm just a simple country lawyer, and I only got this case 2 months ago. Also, I'm unexperienced, but you can't let my unexperience be used against me. Don't hold it against my client. If I try to throw in some twang in there, could work. Yeah. So I might be able to make some noise, but I doubt I could really do anything more than that, particularly with the time available. Although it's half tempting just for the exposure. Although it's not necessarily good exposure, so I don't know. It will support you and be my research people. Oh, Lord have mercy. Neither the facts nor the laws on my side, so pound the table. Preach. Simple country lawyer didn't work in Paltrow. I didn't say it would work. I didn't say any of these things would work. These are just some ideas. And these are all like Hail Mary ideas. You shouldn't understand anything I'm saying as suggesting that any of these things would work. It's like if any of these things worked, it would only be from a pure confluence of genius mixed with luck. I would have to not only I'd have to basically nail it, which, yeah. Oh, I don't think I'm doing this for pay. I'm imagining I'm doing this pro bono. I'm gonna have to do a GoFundMe to pay for my hotel rooms though, or something, because I'm gonna need a couple days lodging up in Florida. If there was a good option, one of the 8 lawyers would have been able to tell her something she liked. Yeah, that's a pretty good indication that I'm not going to be able to pull a rabbit out of a hat, right? If she were able, if there were a way to really do this, one of her 8 lawyers that she had, all of whom have more experience than me, would have found a path forward. So it's pretty unlikely I'm going to find a path forward, particularly given the time frame. So, yeah. Although the expectations are really, really low. That's the nice thing, right? The expectations on me are so low because, well, what's the worst that can happen? I lose. I mean, they're gonna play the tape, man. The jury's gonna hear him moaning for his life, and it's like, what am I supposed to do with this? Not much. Hearsay. I mean, it is an out of court statement being offered for the truth of the matter asserted. Yeah. Okay. Exceptional problem solving skills. I'm going to need some pretty exceptional problem solving skills. That's for sure. I'm going to need really exceptional skills. Yeah. Yeah. So I don't have a lot of hope. I could try to bring the suitcase into court and actually try to get myself into the suitcase. That'd be great. Actually try to fold myself into the suitcase and be like, if I don't fit, you must have quit. Oh, dude. I'm gonna get sanctioned. I can already see it happening. Oh, Lord. Well, I think I'm going to sign off for now. That's the end of the Sarah Boone stupid for the moment. I'm going to sign off for now and contemplate my future. If you've enjoyed this stream, please remember to give it a like, and we'll see what we can do. Okay. Until later, my friends. Hope all's well. Cheers, my friends, for now, and goodbye.